Thank you all for being here. Thank you, Chairman Capito and Ranking Member Whitehouse, for having this really important hearing so early in the term, because there's a lot of work to do, and as we've learned, it takes a while. There are two areas I really love to explore, but I'm going to start with you, Ms. Vilcanis, and Mr. Harrison, really all of you, but you spoke most thoroughly on the topic that isn't anywhere in my prep, but it gets me right to this issue of the capital intensity of these projects is, I think, lost oftentimes on a lot of folks. And even, I mean, to the point of workers. I mean, labor can't just sit on the sidelines and wait for the years to go by. But what I want to ask about is the Supreme Court, and you referenced Sackett, and either you or Mr. Harris referenced the fact that the Corps of Engineers still hasn't adequately responded to that ruling. And prior to Sackett, there was West Virginia versus EPA, or as I like to say, West Virginia, North Dakota versus EPA, and the major questions doctrine. There was the repeal of the Chevron doctrine. All of these are such clear messages that the bureaucracy does not have the power that they think they have and that they've been exercising. And the fact that Sackett wasn't clear enough in the definition of jurisdictional waters, that the durable rule that the administration came up with in response to it was, don't worry about those 80,000 404 permits. Maybe 79,800 of them really weren't necessary, but you should at least ask us first. And you referenced the process. My question is this: what part of this, or why do we even have to seek jurisdictional determination or permission when we know, when anybody can read any home builder can read the law and go, this isn't a jurisdictional water, I don't need a 404 permit. In other words, we don't put a highway patrolman on every car on the interstate just in case one of them speeds. We presume most of them are not going to violate the law. Where am I wrong on this, Ms. Vilcanis? Where am I wrong on this, and how can we simplify it?
So the problem is that it's not clear, and you can ask one person if something's jurisdictional and the next person if something's jurisdictional, and you might get two different answers. So for the construction community, we need clarity, and it's very difficult to move forward when you don't know what is a water of the United States. Not getting a permit when you are in federally controlled water has very significant penalties, civil and criminal penalties, and so the consequences and what's at risk is huge for the developer, for the contractor. Sackett did provide some guardrails. It provided some clarity, but what came out of that Supreme Court decision is not being implemented by the agencies. There, as Mr. Harris said, there are very unclear terms that have not been defined in the regulations, and that's what's causing a lot of confusion.
Mr. Harris, elaborate.
Thank you, Senator. Along with clarity, we need consistency. We need consistency between the core districts. If we could get true definitions of the terms that we were talking about, then our builders, our developers would know when they could take reasonable risk before they make a tremendous investment in both the property and start moving the dirt. So we do need that consistency and clarity.
Well, but one thing's for sure is that they can't be the same as they were before Sackett, right? That there's certainly many fewer jurisdictional waters than there were previous to Sackett. So you're really, as long as there's a 1% chance that it's jurisdictional, you're almost obligated to your shareholders, to your customers, to your workers, to seek the federal government's permission to obey the law. And I mean seek their permission to allow you to obey the law, which is mind-boggling. Okay, we only have a minute left, and I only have a minute left, and we'll explore some more if we get another round. But on the electricity side, because this is the hard work. And I think one of the challenges and one of the things that we oftentimes forget, and this gets to cross, purposes, I suppose, is that electricity is the generation, transmission, distribution in a largely monopoly world of electric consumption, and where where it gets very iffy is that somebody determines those rates. There are regulators that determine those rates, and transmission and generation being built out absent a planning process by the local utility can put the tab on the wrong people real easily. And the solution, there's a solution. We have to find a solution. We have to find a federal backstop. But I think on linear, I think the ranking member's point, linear siting for transmission lines should be the same as it is for a water pipeline or any other linear linear infrastructure. And I think we can do that, but we do have to recognize those state regulators having been one at one point, and the governors, and it's just going to be a lot harder, and we'll talk about it in another round if we get a chance. Thank you, Madam Chair.